Good evening, everyone. Chip Cooper for FTC Guardian and my partner, Alan Cutts. It is now the first Hangout in the month of June, so we're almost halfway through the year. It's amazing how fast it's gone. We're finally settling into summertime where I am. I mean, it's been a late one. I mean, usually we get sort of summer in mid-March and then April we're full bloom, but it's been late, but we're glad to have it. What about you, Cuts? What are you doing?
It's
What are
been
you
good.
up to?
Yeah, we had a good day today. I mean, the sun is. We've had a few days of sun. I mean, nice weather, cool in the mornings, warm in the afternoon. I did 20 miles on the bike today, so I'm happy.
That's good. That's good. The last time I rode a real bike, I was in elementary school. I'm not a bike guy, but 3 mornings a week I ride the stationary bike and don't go anywhere. But I'm on a bike anyway. So, all right. So we've got a lot for you tonight. So we might as well just jump into it. And I've got to make sure that I am doing share my screen. So, Alan, I'm going to drag this screen over here and
I see it now. I see it now.
get it set up in present mode. Come on, come on. All right. Now you should see the full screen, correct?
Yes, I do.
All right, here we go. This is our fifth installment for GDPR training. We call it GDPR 5, and we're focusing on privacy related documents. In this Hangout, we're going to talk about the privacy policy itself and the privacy statement. Let me see if I can advance this slide here. There we go. The housekeeping announcement you've seen many times. The presentation is for informational purposes only. It's not legal advice, and we're not affiliated with the Federal Trade Commission. So here we go. It went into effect on the 25th of May. And there's a quick review here that I think is important. All of these replay videos are in the member area, and there are 4 of them. This is number 5, as I've just indicated, but let's just take a quick look at where we've come along the way with respect to GDPR training. GDPR 1, what is it and does it apply? Obviously, a good place to start. Number 2, data security policies. Now, by way of a quick review, obviously, the data security is very much a part of GDPR regulation, but it's also a part of the FTC regulations as well. It overlaps. So in that second installment on GDPR, we talked about data security policies, the fact that we have 1 or 2 of them in our member area. They're not a part of the GDPR documents. They're part of our regular basic documents in that basic category. Then installment number 3, we really drill down a little bit into the 2 roles that you could play with respect to GDPR regulation. You could be a controller or a processor, or maybe in some cases wear each of these 2 hats simultaneously. And then number 4, last time we talked about opt-in forms, because that's very important when you're wearing the controller hat, and also the data processing agreement known as DPA. So that's what we've covered thus far. And again, those replay videos are in the member area along with documents. So here's what we're going to be talking about in this particular installment, number 5, related to privacy. We're going to be talking about 2 things, basically. A GDPR privacy statement, that's the term I give it. It's not a term of art, but it's my term. And the GDPR privacy policy, which essentially is a combination of your existing privacy policy as amended with GDPR required clauses. And sometimes we might refer to this as an amended and restated. So you basically just amend and restate the whole thing. So basically that's it. You've got a choice. GDPR privacy statement, generally a very short form. It only deals with GDPR provisions. And then the privacy policy deals with both, everything including GDPR. It integrates everything into a single privacy policy that is updated and amended. And of course, if you've been not living under a rock these days, you probably receive dozens and dozens of emails from all sorts of companies that you deal with saying that they have updated their privacy policy. That's some of the stuff we're going to be talking about tonight. And one of the ultimate decisions that you should make regarding GDPR compliance is which one of these alternatives to select or choose for your business, either the privacy statement or the policy. More on that in a few minutes. But before we get there, a little bit of fun. There's nothing wrong with having fun with all of this, I guess. I'm going to show you a few slides here. We're talking about how it almost reached epic proportions, it being the fact that your inbox, well, let's go back. I've tried to go forward. Let's go forward. Your inbox was being swamped by a tsunami of updates to your privacy policy. That's sort of the way I felt. There are a couple of other slides here. This whole idea of the privacy policy amendments over the last month or so has reached the level where people on social media started creating memes, and we've had a hangout about memes, about, it's funny with the way this is going. And you see this throwback here to the Last of the Jedi. You see the beginning of the movie. We have updated our privacy terms, blah, blah, blah. That one's sort of funny. This one is a little bit unusual. Unsubscribe from service, delete email account, sell everything, live in the Himalayas, make fire in mountain cave, humming pigeon appears, has message tied to leg. We've updated our privacy policy. That's, again, I think somewhat funny. But now we get into the more serious stuff, and we need a quick review on the difference between controllers and processors. Make sure we understand it, because that's important in order to determine which you choose, which of these two types of privacy-related documents. The controllers are the entities or people who collect data directly from the EU data subject. So if an individual person in Paris, France is filling out your opt-in form, you're collecting that data directly from that data subject, that person. You're a controller. Now, you might be a processor if you're collecting the data from your customer who collected it from the person in Paris, France. So you're collecting it indirectly, if you're a processor, from your customer who collected it in turn from that individual in the EU. So that's a quick definition and a reminder and a refresher. So let's talk about the concept of bifurcation. That's really my term. I mean, I didn't invent the word, but it's my term as applied to GDPR regulation and compliance. And you can see in white there a pithy definition. It's the division of something into two branches or parts. And that's exactly what's happening when some of us, and we've already talked about this somewhat in prior Hangouts, some of us may want to screen out EU data subjects, particularly from our opt-ins, right? We ask a question: are you an EU data subject? If the answer is yes, then we screen these people out and we provide them information required by GDPR. If they say no, then we treat them the way we've been treating everybody else for the last few years, right? So we separate out, we screen out GDPR data subjects, treat them accordingly, according to the GDPR regulations, and everybody else operates as we have previously. The problem with that is you're sort of doing, you're not sort of, you are engaged in two different types of data protection regimes, right? The old US-based regime and the new EU-based GDPR regime, and it can be somewhat of a problem. However, it might be helpful sort of as a bridge for small companies right now as they transition into full GDPR compliance. And more about that in just a minute. That's what we're talking about there. And one of the classic examples is if you are wearing the hat of a controller, you see this question here: are you a resident of the EU? Yes. Then you're going to have a drop down. This is the screening question. No, there's no drop down. So that's what that looks like. And then if the answer is yes, then you see this additional language for the drop down. You have data rights, you have the identity of the data controller, which would be you, and any of your data processors that you outsource to, such as Amazon Web Services for hosting, right? So that's an example of how that all works with respect to opt-in forms in your capacity as a controller. Now, this is very important. This is for new opt-ins, and you can see that there are really two things that have to happen here. One is little radio button, I guess is what it's called, has to be selected. I agree with the GDPR privacy statement. You remember we're separating out the GDPR data subjects, and we're going to, if they click on the link, they're going to go to a very simple, straightforward, streamlined GDPR privacy statement, and then they click confirm consent, and they are opted in. This is the other situation where you are now a processor, and if you're a processor, you're at the very top of this diagram. It says you are the processor at the top. The EU data subject is at the bottom, and the data flow goes from the bottom to the top. The data subject gives personal information or personal data to the controller, which would be your customer, and then there's a DPA running between the controller and the processor, which is you. So if that's your situation, if you're the processor at the top of this diagram, you're probably going to be looking more at the fully integrated privacy policy rather than the statement, which is the streamlined version. Now, just so that you understand how you might fit into that diagram, these are some examples of how you might fit at the very top as a processor. You provide marketing tools as an online service or software as a service. You're a digital agency which receives customer lists and email lists from your customer. You're a hosting service provider. You're a call center service provider. Essentially any type of online service provider. If that's you, I think you'll probably opting more to the full privacy policy. Again, more on that in a few minutes. So here we go into the issue of how do you select. And I've already given you some clues, but this is sort of the boiling down of the question and the answer. So the GDPR privacy statement, again, very simple, straightforward, only GDPR clauses. If you're doing bifurcating and you're also a controller only, you're not a processor, as we've indicated in the prior diagram, this might be the more appropriate form for you. Not necessarily, but it just might be. Then the GDPR privacy policy, which is the full-blown privacy policy. Most of you have used the one that is in our supplemental category where we have the disclosures for retargeted ads. This is what we're talking about here, except that it's essentially that privacy policy with the GDPR provisions added. So if you look at the sub-bullets below that, if you're not bifurcating or you're acting as a processor, this is probably the way you want to go. Not absolutely required. I mean, you still have a choice, but you probably would tend to go this way, particularly if you are a processor, as indicated in that prior diagram. And of course, you see the second sub-bullet there. You're going to send an update notice that you have updated your privacy policy, right? There's no need to send an update notice if you're doing the GDPR privacy statement. You just provide it there, provide a link to it, and it's done. But the GDPR privacy policy would be an amendment, restatement, whatever, and you need to send a notice. That's what you've been receiving in your inbox for the last month and a half or so. So that's really the sort of the boiled down pithy view of how to make this decision between these two approaches. And again, this one by way of repetition, if you're a controller, you're probably going to be going to the privacy statement. And if you are the processor at the top of this list, you're probably going to go to the full-blown integrated privacy policy. And then, of course, you'll be sending one of these notices yourself. And as you can see here, it's an email notice, right? And the subject line, all you need to say is what we've seen many times before, if we've not been living under the rock, we've updated our privacy policy. Now we get to the text of the email. And if you remember or have saved off any of these emails that you've received about other folks who have amended their privacy policy, and most of those, there are 3 or 4 paragraphs about how we really appreciate and understand your concern about privacy and all of this stuff. It's not necessary. In fact, the more of those I read, the more I'm just turned off by by all of this self-serving stuff. Really, the idea is what you see here in one sentence. We've made changes to our privacy policy to update how we work with international data, period. And then the next sentence, to review our updated privacy policy, click here, and there's a link. And then identify yourself, right? Now, if you want to, this is just an example of a really simple one. You can add more of the text if you like, but really that's the essence of it. That's really all you need to do. And everybody's seen so many of these, there's really no need to elaborate much beyond what you see right here. So that's a classic example of how you might use that. Now, let's take a quick look at some of the clauses of these two documents, and you'll recall that these documents are located on the right side at the very bottom of all the links on the right side of the dashboard in the member area. There's a link there that says GDPR documents and materials, I think is the name of it. And there's all the replay videos of the Hangouts devoted to GDPR as well as these documents. And of course, if you've been in there, you've noted that these documents are different from what you experience with our generator, which is, you generate the document by answering questions with the questionnaire. Here, we've just simply added Word files with all sorts of marginal comments, as you see here from this clip at the very top of the GDPR privacy statement. So you see the marginal comments on the side. You'll see that this particular privacy statement is made by an imaginary company called Sample Co. LLC. All you do is do a search and replace for you there and your contact information. And certainly you delete my comments in the margin. They're here to assist you in understanding what the clauses are. I'm not going to go into any more of the privacy statement. It is very brief, very simple, very straightforward. I'm going to move now to this privacy policy amendment, right? So here we get the very first part of this, and instead of an imaginary company, Sample Co. LLC, I've used FTC Guardian Inc. Again, you're going to do a search and replace, and I have highlighted throughout this document the sections that specifically relate to GDPR regulations. But there are a number of sections that are not highlighted in yellow, which are required by GDPR. It's just that they're not new sections, right? So again, you want to eliminate all of the yellow highlights and yet eliminate all of the marginal comments by me. Now here is one, types of data we collect, personal data. There's a brief definition and then a lot of bullet points. So let me very carefully explain how to go through this and some of the other areas in this privacy policy. One of the things you need to do is to keep in mind the scope of things that you do in terms of data that you collect, personal data, right? So you want to read this and then consider whether you need to either add to it or delete from it, right? So this is a pretty all-encompassing list of bullet points. So one of the things you need to consider is the scope of what you collect. And there's no problem with explaining here more than what you actually do, because as long as what you actually do is within the scope of these bullets, you're fine. For example, the second bullet from the bottom, geolocation data, GPS data. You may not be collecting geolocation data today, right? But you may very well be doing it a year or two from now. So it might be a good idea to leave that in, and it's fine because your scope of use is within these bullet points. The problem would be if you are collecting types of data that are beyond the scope of this list, then you're not following your privacy policy. As long as you stay within the scope, you're fine, but if you exceed it, you're not. So use those guidelines in determining whether to add to or delete from this list. And then that same advice would apply to this passively collected data, which is usage data. Again, you see the geolocation data paragraph. You might just leave it in, even if you don't collect it, because there's no harm, no foul. All right, this one right here is a very important part of this amended and restated privacy policy because it enumerates the data protection rights that individual data subjects have. And I think it's important to indicate these in bold text. The right to access, update, delete your information, the right of rectification, or the right to correct mistakes, the right to object, the right to restriction, the right to data portability, and the right to withdraw consent. This stuff you need to be able to actually do, to actually perform. And if you cannot do it, you need to be seriously working toward the capability of being able to do these things, to deliver these promises to data subjects in terms of their individual rights. So obviously this is a checklist for you. This is required in the privacy policy, but if you're not doing it, you need to really be able to do it as quickly as you possibly can. And then there's another issue here that's got to be changed sometime in the future, and that is the privacy, the children's privacy section. In the existing privacy policy for retargeted ads, our first sentence basically says we don't knowingly collect identifiable information from a child under the age of 13, and that's the compliance for a U.S. statute known as COPPA, Children's Online Privacy Protection Act. It protects children under the age of 13, and that's what we've had in the privacy policy up until this update for GDPR. Now it's 18, which, if you're selling to adults, it really shouldn't bother you that much. But if your website is dealing with, say, teenagers with sporting equipment or coaching or whatever you might be offering teenagers, you've got a problem because you're not in compliance with GDPR. I'm not quite sure how to solve it right there. I know that I've done some research on the issue, and I know that there's been a lot of back and forth within the GDPR regarding the cutoff for the age. One version was 13, one was 18, and finally, when the final draft was released, they went back to the original draft of 18. So something's going to happen here in the next year or two, I think. But that's where we are right now. And then, of course, you need to have your contact information. And the very last piece there, material modifications and clarifications, the date would be the date of your current privacy policy that you have right now that you're replacing. So that's some quick pointers for how to deal with that privacy policy. The key takeaways from this version 5 of our GDPR training would be as follows. Data controllers collect data directly from EU data subjects, whereas data processors collect it indirectly from controllers who collect it from the subjects. Bifurcation is an important concept right now because it involves screening out the data subjects, treating them differently, namely in compliance with GDPR, and everybody else would be treated the way we're treating them or have been up to now. The privacy statement is for use, particularly probably more representative of if you're bifurcating and you're acting only as a controller and not as a processor. You're probably going to be looking toward the amended and restated privacy policy if you're a processor. Those are the tendencies. And then finally, we have tags, pretty simple: GDPR, privacy statement, and privacy policy. So I'm going to now try to navigate my way back away from share my screen, and so that you can hopefully see me, and I believe you probably can. So there you are, Alan. So that was a fairly quick run through. I was hitting it pretty hard and fast there. I'm sure there are probably some questions. So do you see any questions? I can't hear you. Unmute you.
No, nobody has any questions at all. It's all good.
You're kidding me.
yeah, I'm kidding.
I thought we'd be here half the night. But
everybody's got it. They're all good.
That's how it works out. Sometimes when we think that we're not going to have any questions, we have a whole lot.
Yeah. Well, let me start with, because we do have some questions. Let me start with.
You're kidding me then.
No, yeah, we have questions. Let me start with, if you have a question, make sure you don't put it in chat and you put it in the question spot. All right, because with so much stuff coming down in the chat box, I don't see the questions. They start to scroll down, and especially somebody just put in one. Patsy put one. It's like long form, so it takes up all my screen. So make sure you move it over to the chat area and stuff like that. So let's start with bifurcation, and this is kind of a statement from me. And like, if you do not want to have to send out that email, the privacy policy, I've updated my privacy policy, and you probably don't, most of you are probably not controllers. Most of you are processors.
No, you're
opposite.
You're not the opposite. You're not processors, you're controllers.
Most of you
means you got opt-in.
Yeah. So most of you are using ActiveCampaign, Kajabi, Aweber, whatever, and you're collecting the information, but they're the actual person who controls the data.
Right.
Is that right? Controller, yeah, right? Your processor.
And most of those, this is where you're headed, are probably going to opt for that simple approach to privacy statement, very streamlined. The reason why the processors are sort of, and there are plenty of processors that are bifurcating, but the trend is toward the full-blown privacy policy. The reason is the processors are bound in a contract with their customers, who are controllers, called a data processing agreement. And they're getting a lot of data from their customers who collect it from the data subjects. And so for that reason, it's more difficult to be splitting off and that sort of thing. So you sort of, if you're in a processor getting all this data from your customer,
yep,
right, who are collecting it, then you pretty much have to go all in instead of separating out.
And the reason I bring this up is because what some of you may have noticed that are logging in from the EU is Webinar Jam or whatever it is, has somewhat chosen the bifurcation method. Is when you log in, if they tag your IP address as an EU citizen, you have to agree to the settings for EU. We don't see that from the US. We don't see it at all. And I've noticed that
in order to log into this particular Hangout, our members had to go through that.
Yep.
So the people who are here now have been screened out.
Yep.
The people from the EU had to agree to certain things or review certain things, right?
Yep.
I didn't know this.
Yep.
And people who are located here and
people located in the U.S. or had an a U.S. IP address when they logged in didn't see it.
Very interesting.
Yep.
So you're going to see for a while a lot of this, and some of it is happening and you don't even know it. As Alan just explained, I didn't know. But what's going to happen eventually in the next year or two, all of the bifurcation is going to go away. Bifurcation is sort of a bridge from where you are now to the ultimate, where everybody is going to be compliant with GDPR, whether you're a data subject or not. We're just all going to follow it, right?
Yep.
Just the way we did beginning in 2004 with California, who had the first privacy policy.
Yep.
We couldn't screen out Californians, so we all complied with California law.
Well, I mean, that's what I have said all along. Since this year is coming up, is that the FTC is going to follow GDPR, and they're going to start to say, well, we're not going to get left behind. We're going to follow that regimen, which they're going to start to follow that same routine because it's only going to make sense.
Here is one extremely important point, and I skipped over it because I was moving too fast when we got to the clips at the very end. And this is extremely important. Under our existing privacy policy, not this one with the GDPR added, we have a very significant distinction between personal information that can identify a person and usage data, right? Because originally the FTC felt like that PII, which is the abbreviation for personally identifiable information, is what we really need to protect because it identifies a person, right? But this usage data, it doesn't identify. It's anonymous. We don't have to worry about it. But we learned a few years ago that that distinction doesn't apply anymore because now with data mining techniques, you can identify a person with theoretically anonymous usage data, right? So the whole foundation of the way the U.S. approach has been to privacy has just been blown out of the water by data scientists, right? However, GDPR closes this loophole, I guess you might say, because now usage data is considered personal data. I'll say it one more time. If you look at those bullet points that we went through for what is personal data, name, email address, blah, 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 blah. Well, one of them is usage data, which up to now has been considered not personal information based on the U.S. Situation. So that's a big change. I forgot to mention it because I was going too fast.
All right, I'm going to make one more point here before I start getting to some more of the questions. We have a lot of questions now that people are starting
to. You are kidding me.
Oh yeah, people are putting stuff in chat, but they weren't in the question box. So I wish I said that because it's hard to see all that stuff. So I forgot what I was going to say. Is the I forgot what it was. I'll come back to it. Let's get back to the
go to the question.
Go to the question. Let me start going to the questions. For example, we don't have a signed DPA with Active Campaign. I had to tick a box to say I agree with their DPA in order to continue to use Active Campaign. So people are asking, do I need a signed DPA from this? In this case, it was Kajabi. I've had 2 or 3 people say Kajabi, who is the one who handles their emails and stuff like that.
Well, see, you've heard that joke about the cobbler's children have no shoes or something.
Yeah.
That's what applies here. I've been so busy working on clients and also getting these documents up and trying to do all this. I haven't worried about practicing law for FTC Guardian very much. So yes, I mean, if we're having sub-processors, the transferor's responsibility, the person transferring that data to Kajabi, has the legal responsibility of getting a DPA between the two. However, Kajabi also has its own version of a DPA, very favorable to them, I'm sure. So, it doesn't matter where the DPA comes from, whether it comes from us and runs to them or them, whoever, doesn't matter who originates and presents the DPA. So, yeah, you can probably go to all of our service providers and find a DPA that they have that you can download, execute, click through on, however you accept.
Yeah, I click through for Active Campaign. I click through for Active Campaign's DPA, just, because basically a lot of people are treating that the same way like Facebook. Do you want to use Facebook? Then agree to all of our terms and services, right?
Right. So what questions do we have? I want to get started on that.
Yeah. Do autoresponders companies take care of GDPR for us? You want to just answer that? I mean, I could, but go ahead.
Just about email, right?
Yeah, Do autoresponder companies take care of GDPR?
I have no way to answer that question because I don't know what they're doing. But
let me answer it. Basically, they take care of if you've got an AWeber, an Active Campaign, or something like that, they're taking care of it's the controller side, right? Because they're the upper end.
Well, I assume they are, but I don't know what they're doing. I mean,
if you're as an autoresponder, if you're collecting names and email addresses, then you've got responsibility for the other side of it.
Well, here's the way I would answer it. There's no way I can answer that question because I don't have the information sufficient to answer it. But if you go back to I think it was GDPR number 3, where we talk about the opt-ins, right? One of the key slides in that opt-in presentation, and by the way, there's another version of it the slides have been converted to a PDF, and it's in the list of documents in the GDPR documents. All you have to do is download it, and you can, save it on your hard drive. And it goes through all of the examples for opt-ins, right? including opt-ins to an email list, right? So I'm sort of getting to the answer, right? But one of the key parts of that series of slides is called record keeping requirements, right? So if you're collecting email addresses through an opt-in, right, you not only have to get you have to get consent in order to do it, and that's covered in the PDF. But you also have to keep records about how and when you got the consent and all of that sort of stuff. So there's no way I can answer for that reason. They may be getting consents, but they may not be keeping records for you. So there's a lot more than just getting the consent. There's this whole record keeping situation. So one of the things that we promised to do, and I'm going to depend on Alan a lot, is to keep a lookout for services that start automating some of these record keeping processes for you for a fee. I mean, it's going to be a monthly service, and I'm sure there are a bunch of them out there working on it right now, so that all you do is sign up, and you sort of tie in your opt-in with the record keeping online service, and they do that for you. They manage your list and the consents, people opting in, opting out, all that stuff. So that's the way ultimately to do it, other than doing software development yourself to create the software systems to do the record keeping, which is not a very appetizing idea for small businesses. So one other comment that's related to this, and I think I mentioned this last time, but in the conference I went to, literally the second day of the conference was May the 25th, which was the day that all this kicked off, the effective date of GDPR. And I'd never heard this before, but some of the people on the panel said there's this idea of perfect compliance, perfect in every detail, right? And basically they said they think that it's probably unattainable, right? And these are big companies, House Counsel and outside counsel representing big technology companies that have spent millions of dollars apiece working to become compliant on that very day. And they thought, well, we're pretty close to being perfect, but we're not. We just know we're not there. There's just so much that has to be done. There's got to be something that we hadn't, you know what I mean? Even though we spent massive amount of time and effort. But if you apply this concept of perfect compliance to the small to middle-sized company, which is what we have here in terms of our members, most of you guys are not nearly perfectly compliant right now, but you need to start, and you need to be moving toward it in a reasonable way. And that's what we're here to do. It's past May 25, and some of you are going to be amending your privacy policies, right? So you didn't get it done by the 25th of May, right? We're past that, but we're working to this goal of perfect compliance. And we believe that as long as we keep at it on a very steady pace and work through this, we're going to be fine. The big companies, though, they're going to be the targets early on, and they've spent a lot of time and effort and money trying to approach that level of perfect compliance.
Yep.
All right.
I have one from Juliana. Turn your volume down a little bit.
Turn it down?
Yeah, just a little bit. I'm going to get feedback.
All right, it's turned down.
Okay. Juliana, I have a website for a brick and mortar practice in Georgia. I do not collect name and email addresses. Do I need GDPR update? From a marketing standpoint, I wouldn't be concerned. I mean, you want to have your privacy policy, you want to have your stuff, but
let me answer. The answer would be no. I mean, here, if you're not getting personal information of EU data subjects indirectly from your customers, and you're not collecting it directly through opt-ins, except that maybe somebody just stumbles on your site every now and then from Europe and signs up for something, you're not targeting EU data subjects. You don't have a sales page in the French or German language. You don't take payment in euros. You don't have testimonials from guys from Paris, France. So you're not targeting, you're not regulated. But that doesn't mean that you shouldn't be, attending all these hangouts, because one of these days you will be.
Well,
it's just a matter of time. So you might as well be thinking of it.
Yeah, one of these days, very soon, FTC will be very similar to GDPR, and you need to make sure that you're working your way towards that.
I guarantee you, in the next 3 to 5 years, everybody, I don't care how big or small you are, it's all going to come together. So the smart approach is not to say, well, I'm not regulated right now, I'm out of here. And go. No, you need to be aware of this and be working toward it, or thinking about it at least, or at least aware, because it's here. It's just going to happen. Right?
Yeah. Okay, question from Bill. Do we replace the privacy policy with our new document, or do we have both the same page or different pages? One page. You're going to do one page. Now, if you go in and you do what Chip told you to do, remember, you replace that whole page with what Chip has put in the Word document and do all that, then that's going to require you to send an email to your list. Am I correct, Jim?
Right.
Yes, just
yes. Right. But the direct answer to the question is yes, you're replacing your present privacy policy that has the retargeted ads disclosures in it with this one that we just put up, the full blown.
Yep.
And once you download that Word file, you'll see the yellow highlights. It'll indicate what the GDPR language is, and it's all sort of meshed together. So you replace the one you have now with this one, but before you do, you read through some of these things and follow the rule that I was talking about. If you're within the scope of what you've disclosed, you're fine. But if you're outside, you need to start trimming back a little bit. So don't just copy it up and replace it. Read those types of data, read through it, and modify it accordingly.
Okay, so what I'm going to tell you is, to make sure everybody understands, is if you go to your privacy policy, you click on the little section, there's a spot where you can edit it. You can edit, you do it all the way down to the bottom, there's a modification and edit, and that's where you would go. You click the little button and you put it in there. You know, after you've read through it and everything, you copy and paste it, and you're going to drop it in there. Then
basically, you copy what we've got is new. After you review it and maybe revise it, you copy it. Then you go into where you are now and delete what you have and paste this in the spot where it was, and then you're fine. That's how you do. And then you send out your little notice.
Yeah. Now, so that everybody here knows, is that we have two things you can do. Is we also have a little pop-up that you can put on your website that's been there since the beginning of time, that you can say, we've updated our privacy policy. So somebody goes to your website for the first time, and you can click on your website, and you can click, when you generate the pop-up, you can click a button that says reset. So somebody goes to your website for the first time, this little pop-up is going to come down and says, we've updated our privacy policy with a link to your privacy policy. And if they click the X and accept, then they've accepted, they've already been there. Now, I would be remiss if I didn't mention this, because I'm a marketer. When you send out that little email that says we've updated our privacy policy, I just had Chip write a new article last week. You could put something to the effect that you've done all this because you love FTC Guardian. And if you're an affiliate, you could put a little link to FTC Guardian that you use FTC Guardian as a service.
Now, all of you listening, you remember if you attended our webinars, we talk about how Alan and I have our little friendly arguments and things on the Hangouts. This is not an argument, but clearly he's the marketing guy. And I would have never thought that. And you can do it, and it's voluntary, but he's a marketer, so he made the suggestion. That's fine.
So think about it. I mean, you can say you add a little quote, blah, blah, blah. We update our privacy policy, link to your privacy policy. And then you say, to review an article by Chip Cooper, our attorney or the attorney for FTC Guardian, we follow FTC Guardian's rules and guidelines. Click here. And I've had an article done. Now, I haven't put the article up yet. Chip just wrote it this weekend, and I'm still reviewing the article to make sure it's... So you could do that. And the article would lead people to learn more about it, as well as opt into a webinar and stuff like that. So it's out there for an option. If you're interested in something like that, just email support, and we make sure that you get a link to the article when you do it, so that you can add your affiliate ID to it.
You didn't tell them where to get the link.
We don't have it yet. It's not even up yet.
Well, I mean, when you have it, they don't know where to get it. So, but
Yeah.
anyway,
Well, they're going to email support. They're going to email support and say, "Hey, because not everybody here is an affiliate, and that's the reason
okay.
I say it. Not everybody here is an affiliate." So,
What are the other questions that we have out there?
we're going to get through those. So, sellers who don't use an email address are neither controllers. It says for Etsy. I don't know if you know what Etsy is. It's kind of like an eBay, or it's a seller location. I've bought stuff. I've never sold anything on it. Etsy, who don't use email list, are they neither controller? If you don't use an email list, if you don't have an email list, you're neither controller or the processor.
Yeah, I mean, the whole idea is, are you collecting and processing personal data of people who live in the EU, right?
Yeah.
If you're not collecting that data, then you don't have anything to worry about.
Yeah. Ricky, how do you determine an EU citizen just by asking if they're qualified? Other than that, you could use IP address. That helps a lot. Although what I have been told through other people, not Chip, that even if they're an EU subject, I mean, if they're an EU subject and they're living in the U.S., it still applies.
Yeah. So the IP address screening device is not foolproof.
Nope.
So I like the one that says, "Are you a data subject? Or are you an EU data subject?"
Well, that's the reason she's asking. But even if they ask, "Are you EU?" and they click the other box, then and say,
but if
no.
they're lying, I mean, there's nothing you can do about that. But I think that's by far the more effective of the two. The IP address, there's some problems with it, but better than nothing.
If you're starting online, just starting online,
Let me guess. They're asking the question: does GDPR apply to them?
Yeah, no. If they're just starting online, to sign up for the newsletter, to buy our products and services, some on Amazon, do we just start out with the simple privacy statement? Yes. Just if you're just starting out, you're brand new.
But here's the ultimate question: are you even regulated by GDPR right now? If you're not, if you're not collecting data from a customer, that's collecting it. If you're not collecting data from a controller, if you're not a processor, then the next question is, are you targeting EU data subjects? Do you have a German language sales page? Do you have French people doing testimonials? Do you take payment in euros? If the answer is no, you're not regulated at this time. You're a new business. You're not regulated. But if you're targeting those people and you're collecting data, then you are. So it may be that right now you're not, but sooner or later you will be. So stay tuned. Don't just say, "Hey, I'm checking out of here."
Kajabi, Aweber, Kartra would be processors, and the controller is the collecting of the data.
They're processing, right?
Yeah, they're asking if Kajabi, Aweber are processors versus controllers.
Yeah, they are.
Okay, so they're processors.
I mean, think about it. FTC Guardian has members. We collect who are individual people, right? We collect their personal information, right? So we have it, but then we use Salesforce.com as a CRM marketing tool. For example, we don't, but let's assume we did. They're a service provider for us. They're a processor, right? We collect the data, we're a controller, then we pass some of it along to our CRM processor. So service providers are essentially processors. Yeah. That's the general rule.
Okay, now this is Vicky. Are there any surveys or anything that says what documents we need to? The only document that you would really need to update would be your privacy policy, or either if you're using the BIFR, whatever the big word is, the other document that Chip has in there. If you're new starting out,
if you're not regulated, you don't need to do anything.
Yeah.
If you're regulated, if you're not a processor, but you're starting to collect and some of this stuff, then you're going to need to follow the rules on the controller rules. Download that PDF that's in the documents and follow the methodology there. and there's going to be a link to the privacy statement.
Right. Yeah. And, there's no terms of use. You don't need the legal statement. It's the privacy policy is where everything is pretty much at. Does GDPR fully apply to business activity, B2B? Because FTC overlays B2C.
Let's be sure we understand. Let's get back to basics. It applies if you're collecting individual persons' personal data who reside in the EU, right? If you're not, then you're not. So the whole idea is that guy or that woman who live over there, they have certain very important rights related to their personal data. And if people are collecting it and archiving it and processing it, they've got duties owing to these people, right? But if you're not collecting their name and email address and other elements of personal data, then you're not regulated, right? It's all about personal data from EU data subjects. If you're collecting it directly or indirectly, you need to be thinking about GDPR.
Yeah. All right. And Loba, it took me a while to get this as well. Can you please explain the difference in simple terms between a controller and a processor? Most of our people are most likely what?
Controllers.
Most of you. Let me. I want to do it in simple terms, Chip. No legal mumbo jumbo.
No, it's pretty simple. It's pretty simple.
I want to make sure they understand. It's like most of us are just the controllers. We just capture the data, right? We don't process data. But now, if you were a Weber, if you were actually a Weber, then you would be both a controller and a processor, because you're probably doing the same. You're processing other people's data, but you're also trying to build your business, so you're capturing data. So right. You could be both the processor and the controller.
Let me add to that. Think about this. You have an online business. One of the things that's important for growing your business is to build a list, right? That's one of the most, if not the most fundamental thing you can do. So when you are in the process of building a list, you're a controller. You're list building. You're collecting a name and an email address from me. If I live in Paris, France, it's from me, but now I'm an EU data subject and I'm going into your list, right? So think of it that way. I'm list building. I'm a controller. I'm collecting the name and email address and maybe some other things directly from a person, right, who lives there. That's what controllers do. The service providers are generally much more mature businesses, right? Service providers are selling services to other online businesses, right? So it all depends on who your customers are. If you're just list building individual people, that's one thing. But if you're selling, if you're Amazon Web Services, you're a processor for a lot of companies that are collecting data, right? You're hosting a lot of websites. So you're a service provider, and your customers are all sorts of business, many of whom are collecting data from EU data subjects. So think of it this way. The processors are generally much more mature businesses, much larger, because their customers are other businesses, right? The beginning people in this business of internet marketing are typically pretty much restricted to being controllers. They're selling stuff directly to people, right? Training programs, whatever, membership stuff, and they're just list building. So they're controllers.
Yep.
But there's more information. I believe it's in GDPR 3. Go watch that replay video. There's a lot more information about controllers and processors in there, and that'll help you.
Great. Yeah, Loba said thank you. She got it answered. Another one from Marlene is the URL for the privacy policy document. It's all inside the membership area, all the way to the bottom. GDPR. Click on the GDPR, and there's a link in there for the. It's a Word doc for the document. Right. It was actually uploaded yesterday.
When you log into the members area, there's a picture of me there. A still picture of a video welcoming you, and I'm sort of looking at like this. Well, then on the right side of the page at the very bottom, you'll see a link that says GDPR documents and materials, I believe. And
Yep.
then you go in there and there's all the replay videos stacked on the left side and the documents which are downloadable. Almost all of them are Word files, but there's this one opt-in form one that's a PDF. So it's all in one place.
Yep. And this is from Shelley, and I think I know that. I mean, I know the answer, but if you can quickly answer it, what if someone is currently located in the outside the EU, but then later moves to the EU?
Too complicated.
Yeah.
I mean, when you captured their name, they were living in the U.S. and then
were they a citizen of?
Well, it's not a citizen; it's a resident.
Resident of.
So let's say I lived in California, and then I decide I'm tired of California. I want to go to France. So I'm a resident over there. I'm still a U.S. citizen, but I'm a resident there. You collected my name when I was a resident of the U.S. and then I moved. Don't worry about that.
Yeah. Yeah.
I believe the answer is where was I when you captured when you originally captured the data?
If somebody makes a purchase, doesn't their information become part of the transaction record, thus need to be saved? That is saved in our case with one shopping cart.
Let me answer that question.
Yep.
Part of the question, I believe, goes to how long you can retain data. There is a little section in this full-blown privacy policy titled data retention. And it doesn't go into really great detail, but you're not supposed to just keep somebody's data forever, right? So there is a brief description there. Read the privacy policy carefully. You're not so at some point you're supposed, obviously when they're still a member and a customer, you keep their data when they're active. But when they're not, you're supposed to gradually dispose of this data, delete it, and not just keep it there so that you can be hacked and the data can be compromised. There's going to be more information in future Hangouts about that. We haven't covered that directly, but there's one little paragraph in the privacy policy. Read that, and that's about as far as you need to go now. We'll expand on it later.
Okay, from Bill, if I can't bifurcate with my software, should I use the policy, or must I use the policy instead of the statement?
There are two privacy-related documents. One I call a privacy statement. That's the brief one that most the people who are bifurcating are sending people to. The other one is a fully integrated privacy policy. But the real question is, are you regulated by GDPR right now? If you're not, you don't need to do it, right? So again, are you targeting you're not a processor. Check that off. You're not a processor, you're a controller. Then the question is, are you targeting EU data residents? And you've heard me say this many times. Language, currency, testimonials would be evidence of targeting, guys. If you're not doing that, but somebody stumbles on your site from Paris, France, maybe 2 or 3 times a year, don't worry about it. You're not targeting them, and you're not regulated right now. That's the big question. You need to keep in mind, are you regulated? And if you're not a processor and you're not targeting, you're not regulated right now.
Yeah. I mean, I'll give you guys an example. I mean, for FTC Guardian, we do a lot of advertising. And although we have a lot of EU subjects as well as Australian and Canadian and stuff members, I have never, ever targeted anybody outside the US, ever. All the Facebook advertising, Google AdWords, retargeting ads, anything I've ever done, I have never retargeted, or I've targeted anybody in the European Union or Canada, for that example, or New Zealand or Australia. I have never targeted them. Not because I knew anything about, not because I didn't know anything about this. It just wasn't our marketplace. I mean, our core marketplace is US.
But here's where we want to be careful about what we're saying here, because You're right. I agree. I know enough about what you're doing, Alan, to know that we are not targeting. Obviously, Alan does that work for us. He does the ads. But at some point, even if you're not targeting, but you start looking at your list and you're seeing a lot of the list, the segment of the list that is comprised of EU subjects is not just trivial. It's just growing, even though you're not targeting them. It's growing, right? And so at some point, you have to cross a line and say, well, we're not targeting them, but for some reason, we're attracting them. Well, right? They speak English. They pay in US dollars, not euros. So maybe we ought to feel like we're regulated. But you're right, we're not targeting. And I think right now we're probably okay. But if we keep increasing
well, that's the reason for FTC Guardian. We have chosen the path of moving towards the GDPR, right. Everything else that we need to do, but we're not overly concerned right this moment about being totally.
However, I said at the very beginning of this presentation, it's sort of like the cobbler's children don't have any shoes. so I'm not going to hold FTC Guardian up as the shining beacon of compliance right now because we've been snowed under by all this stuff. So rather than getting our house in order, I've been trying to get your house in order with this material. So we're going to catch up. We're going to catch up. But I think right now, it's funny to joke about it, but I really believe that we as FTC Guardian are not regulated right now. I really believe it.
Yeah.
But I think we may be getting there pretty close, and we'll deal with it later. But right now, I believe we're pretty safe, that we're not regulated. But we need to watch.
And you're talking about something, 44,000 plus members, and again, the predominant members are U.S. based.
Right. I mean, if it's
Canadians, we have UU,
we have targeted them, and it's minuscule. But if it's starting to be 500, 600, 700 out of 4,000, maybe.
Yeah.
So we're not targeting. We ought to think about being compliant.
Yeah. So, I mean, I hope you get a lot out of that, just that right there. We're not targeting them. So, yes, you need to work your way towards that. Yes, you probably need to start updating your privacy policy and all these things. But and that's the reason we, as FTC Guardian, didn't rush to May 25th. I mean, one, Chip was busy, but at the same time, he's also busy reading and understanding everybody else's DPAs and what everybody else is doing, so that you're not just jumping because everybody else jumps. You're actually getting information that is thought out, it's logical, it's been well positioned, instead of just going out and doing like a lot of people have done and just throw it out. We've updated our privacy policy and just put something out there about GDPR. We don't know what the hell it means, so we're just going to throw something in there and bada bing.
There's been a certain amount of I would use the word panic almost. I'm not sure that's quite accurate, but there were a lot of people that got all excited about all this publicity and everything, and all the articles written about it, and then all the influx of all the notices for, oh my gosh, but one of the good things about us, thank goodness, is that the vast majority, in fact, almost if not every one of our members is not these bigger companies, right? You're the smaller people who are transitioning in. So we're not under a tremendous gun to get everybody 100% compliant by May 25. In fact, we couldn't do it anyway. We didn't have the capacity of doing it. But we're doing a more, reasonable approach. We're setting up this pathway, and we're going to continue to do it. In fact, I was talking to Alan earlier today. We have these 2 Hangouts every month. So for the foreseeable future, one of our Hangouts is going to be on FTC stuff, and one of them is going to be on GDPR. We're just going to keep going. We're on 5. This is number 5 right now. We're probably going to do another 3 or 4 or 5 maybe toward the end of the year about the key points, so that by the time 2018 is done, there's going to be a complete, not absolutely complete, but a fairly complete list of replay videos and documents and the whole program. So, and thank goodness it tends to fit who our customers are and the size and where they are, that sort of thing.
Yep.
Any other questions?
Yeah. Is it okay to use software that looks at the IP address of EUs and redirect them to a different page. We talked about this before. You can do that, but at the same time, it's not 100% because we go back to the example. What if you have an EU subject that's in the U.S. using a U.S. computer here on vacation? They are still under the EU.
Right.
But I mean, it's a good way, but it's not 100%.
It's not a guarantee, but I think if you're doing that and relying on it right now, where we are just after this thing has gone into effect, there's not going to be any problem with it in terms of non-compliance. So you're not perfectly compliant, but you're really, you're making a serious effort. And right now, I think that's going to be sufficient for most of the people on this call.
Yep. I think, let me see, it says, I saw something here that says, thanks, Alan. Thanks, Alan, so much for this as an hour earlier than normal, missed the live webinar, blah, blah, blah. All right.
So you've got some fans out there.
I got fans. Yeah. So let me see. I got call. We got answered. Does a DPA, does a DPA have to be signed? Like with Active Campaign, we have one with Active Campaign, and I agreed to it.
It's got to be executed. Now, some of them have the little way that you can do an electronic signature in a PDF file. Some of them are click through. Right?
I clicked through. I did a click through.
So, but it has to be accepted, right? I don't think it requires an actual pen to paper signature, but there are different ways to, click through on an electronic or have an electronic signature, various ways, that sort of thing. It cannot be what is called a browse wrapped agreement where you just post it and nobody has to click through on it or sign it or something.
Yeah.
An affirmative step has to be taken to accept it.
Yep. I have one, and this is the question, and I'll give you a couple of seconds to answer. Do we have any enterprise members on the line tonight? Just give me a quick yes if you're an enterprise member. I'm going to post something in here if we've got enough enterprise members. Let me find it real quick. Hang on, let me pull it up. Enterprise members. Yeah. So I'm going to post this video. This is don't watch it right this now. Copy the link and go watch it later. I've been looking, we have affiliates, right? Enterprise members. We have a lot of affiliates. You don't have to be an enterprise member to be an affiliate. You can be a pro member to be an affiliate. But we have enterprise members who are really taking advantage of our enterprise membership and using our affiliate program. And this is a person that we pay a lot of commissions to every single month. And we have a number of them, but this guy just has really stood out to me. So I reached out to him and said, yo, what are you doing that I end up paying you so much every month? I mean, it's kind of crazy because you're above everybody else. And I asked him, could I interview him? So I interviewed him, and I put it on a YouTube video. I just uploaded it before we hopped on this call. So if you're an enterprise member and you want to really know how to use the enterprise system, or you want to be a enterprise member at some point, watch that little YouTube video. His name is Paul, P-O-L. He runs a company called Digital Navigator, and he's crushing it for us. I mean, for FTC Guardian, he uses FTC Guardian as an upsell and into his bringing on clients. So watch the video. It's there. I just did a quick interview. I let him do most of the talking. And for me, what the neat thing is he is an accountant auditor by trade. That's where he's educated, and that's where his degree is in accounting and auditing. And he's a huge success in as a digital marketer and running an agency. Since GDPR, here's a question. Since GDPR is the right to be forgotten, if an EU customer wants to be forgotten, we must delete the transaction data, or can we delete the customer transaction data after the request?
This is something we're going to drill down on in detail in a future Hangout, right to be forgotten, right? But the idea is you as a business person have certain legal obligations, one of which is to the Internal Revenue Service, right? So that some of that transaction data you have a right, in fact, a legal obligation to keep. If you get audited, if your business gets audited, you need to be able to show where your income came from, right? So you don't just delete everything. So you need to make some decisions about what is fundamental for you to retain for tax purposes primarily, or any other legal purpose, but where you have to have that information. The other purposes that are not necessary, then at some point they have to be deleted. And we're going to talk about data retention, right to be forgotten, and all this stuff. Probably, I mean, that's a good idea. We take feedback from you guys, and that might, move that up on the priority list until maybe in July. That'll be one of the GDPR hangout we have. I'll add it to the list and see if we can squeeze it in.
Yeah,
So yeah, we're going to cover all of this stuff in time. But what we wanted to focus on first were the fundamentals. What's a controller? What's a processor? What about the agreement between the controller and processor? What about your privacy policy? What about opt-ins? That's sort of the most basic stuff. Then we're going to be drilling down to the record keeping, and we've talked about it a little bit. We're going to talk retention data, right to be forgotten, all of the internal stuff. We're going to get to it. We'll take it one a month. We're going to take it probably through the end of the year or close to it before we sort of get most of it, under control here.
Yeah, so this is from Larry. Do we use the provided doc as a Word doc template by changing, for example, sampleco./trustandcompliance.com? I don't know where trustandcompliance.com came from.
There is a document that is in our list of GDPR related documents called Trust and Compliance web page. And this is in connection with a data processing agreement where we have in a couple of web pages where we have some links to certain documents and a list of sub-processors. But if you're not a processor involved in these DPAs, binding a processor and a controller, you don't need to go there. All right?
Okay, well, this one says sampleco./trustandcompliance.com. So they can.
I don't know what that is. I just know that there is in our documents list a little web page that has some links, and it only applies to processors and controllers in the context of a DPA. If you're not involved in that, don't worry about it. And I don't know how. So it sounds like there's something that got mixed up, because it's a link to a web page that should be on your website, and the anchor text is trust and compliance documents, I think, or information. I don't know how this document.
So the link on their web. So the link, for example, the link on our website would be what? ftcguardian.com/
trust and compliance.
Do we have a trust and compliance?
We don't have it yet. No, we don't. We're going to get there.
Okay. Okay. Got it. That's what they were asking about. We'll answer this. We've got to get going, but what is a DPA? Data processing. Somebody's answered it. Data processing agreement.
Right.
Sarah got it.
Here's the idea. If you are a controller, when the vast majority of our members are controllers, right? We've decided that tonight.
Hang on a second. We want to do this. Larry just asked the same question, so go do it again. Larry's the same.
The vast majority of the people on this call and our members in general are controllers. They're list builders. They're collecting information from people directly who live in the EU through opt-ins, right? So now they have this data, they control it, they archive it, and they process it for some purpose, maybe just to send out emails, whatever, they process it. They're a controller, they collected it directly. But then, this is you now, you're a controller, you're outsourcing some of your functions of your business to a data processor. And the classic example I always use is a CRM. such as Salesforce.com, or Amazon Web Services, who's hosting your website, right? Because they have physical possession of this data. So now you're engaging a CRM, you're engaging a hosting service, and you're engaging an email service provider, right? And so in the process of engaging those service providers, you're transferring some of the data that you've collected to those people. Because the CRM guy has to, send out marketing emails maybe. The hosting has to host the data, right? So in the process of entering into these arrangements with these service providers, you're the controller. You're responsible to bind your company to that service provider with a data processing agreement. And since you're the person transferring it, not receiving it, you're transferring it to Salesforce. That's the DPA, the data processing agreement. And the general idea of it is to make sure that there are the ample safeguards that CRM, that Salesforce has agreed to do certain things regarding that data, right? That's the purpose of a DPA. So either you're a processor and there's going to be a DPA with all of your customers, or you're a controller and you're transferring data to a processor, you need a DPA. And that was one of the first things that we covered in our prior coverage of GDPR. Look through we've got a DPA, we've got some related documents to a DPA, and we have at least one video that talks about it in great detail. But that's how it works. That's the purpose of it.
Okay, we're going to wrap up because I think we've just got all the questions. And I should have said this earlier, being the marketer that I am. If you guys enjoyed this, go to our Facebook page at FTC Guardian, Facebook/FTC Guardian, and post comments about on the main page. Because again, we want to bring on more members after, we want to do that. And we need posts that say that, you enjoyed our Hangouts,
I'll tell you, I'm going to put on my marketer's hat here, put it on. Yeah. I don't do this very often, but here's what I would suggest. I believe we still have in that dashboard of our members area, when you log in and see the picture of me, I believe in the middle on the right side, there's a little blank thing that says, leave us a testimonial.
Yep.
Right. Here's what I'd like to see. We're starting to do a lot of pro-level membership related webinars right now. And there's a lot of people interested, as you might imagine. And if we could get a couple of 3 really good testimonials from people about the GDPR coverage that you're enjoying right now. I don't know if you're enjoying it, but you're participating in it. Anyway, I don't enjoy going to the dentist, but I know I need to go, right? So if we could get 2 or 3 really good GDPR related testimonials saying, wow, you guys are really taking care of us. We're getting documents. We're getting all these Q&A things done. We're going to pick out a couple of those with your permission and use it on some of these webinars. That would be really helpful. We've got some really good testimonials that aren't GDPR related, the ones that we collected the last year or 2 or 3, right? But this GDPR thing is brand new in 2018 for us anyway, and for you. So if you really want to help us out, that would be really very much appreciated. Now I'm going to take my marketing hat off, put it down. That's what I'd like to see, because I'm the presenter on these things. I'd like to pick out a couple really good ones and put it in there. I think it'd be very helpful.
You want to do a video? All the better. You want to do a video? All the better.
In advance. Thank you very much. Yeah. So is that all?
Yeah. So Kathy, so if I'm using Aweber, do I create a DPA for Aweber to sign?
Aweber, you're supposed to, but Aweber has them. And see, let me mention this is the last question. It's your responsibility because you're transferring data, which is email names and addresses, to Aweber for sending out marketing emails. So it's the transferor's responsibility, not the recipient, to make sure there's a DPA. That's the law. But let's talk about reality, right? I guarantee you, Aweber is not, if you submitted your DPA that you copied, downloaded off our website and changed the names and sent it up there and said, here, sign this, they would say, are you kidding me? No, we don't. You download ours. You know, there's a DPA. We've got one. You signed the darn thing. The same is going to go Amazon Web Services. Can you imagine contacting AWS and saying sign our DPA? They're going to think you've lost your mind. You know, they're not going to deal with. They're going to impose their DPA on you. So that's the way that works. But
so,
you know,
just so you guys know, I mean, we as small business owners are the smaller fish, and we have to agree to the other person's DPA and accept it.
It's just a matter of leverage. But legally, you know, when we outsource to a service provider, we're the transferor of the data to that service provider. Then we have the legal responsibility to present we have the legal responsibility to make sure that there's a DPA. It doesn't matter if.
Well, let me get to it, because I mean, a lot of what Chip has been going through, because Chip works with a lot of very large companies, is Chip has been negotiating DPAs with companies, because everybody says, "Oh, I want to use my DPA," and nobody says, "No, I want to use my DPA." So Chip has been in the business of the last 6 months negotiating DPAs between companies, because they're a lot larger fish than you and I are, right? They're not FTC guarded. So he's negotiating DPAs between companies. So that's to where it's at. I mean, we as the small business owner who are using a Weber, we have to do it. Now, if you're a Salesforce and you're trying to do business with Dell, you're probably negotiating DPAs between each other.
Maybe not. I mean, it all.
Yeah. It depends. It depends on who wants whose business, right?
I've got a client who's got the clout as a processor to enforce its DPA on its customers who are controllers, right? Because they've got the clout. But then one of their customers is IBM. Guess who had the leverage going up? So it's all about leverage. But you know, so if there's a legal issue about who's responsible to make sure it's in place, and then there's the real world of leverage to decide whose paper it's going to be. That's what we're talking about.
Yep.
All right. That's it. We're done for tonight.
We're done. This is, I think, probably the longest one ever. I mean,
I knew it was going to be long, and I knew you were kidding me when you said we don't have any questions, because I expected a lot. And by the way, we appreciate the questions. That's what we're here for, right? It's not like we don't want to answer questions. We do. Yeah. And this is one of the better Hangouts we've had in a while. We've had a lot of questions, a lot of discussion, and I hope it's been very helpful. We're going to continue probably through the end of the year every month, alternating between an FTC-related topic and a GDPR. That is all for tonight.
So tell your friends, your marketing friends, become FTC Guardian members.
Yeah, and give us one of those testimonials. We'd love to use it on a webinar. All right, that's it. Absolutely. Trust me, we're done. We're out of here. Have a great evening, everyone. Good night.
Thank you. Bye-bye.